Pop culture paints divorce as a glamorous, high-stakes battle. Two angry spouses, two ruthless lawyers, and a stern judge slamming a gavel to declare a winner. But stepping into the physical reality of the UK family court system reveals a very different environment. This timeline visualizes the lifespan of a standard family dispute today, showing a system buckling under its own weight. Private child and financial cases often sit in limbo for 4 to 6 months before parties even reach a preliminary appointment. Final hearings are routinely marked at risk, meaning they have a high chance of being canceled at the last minute simply because there are too many cases and too few judges. This endless waiting drains bank accounts and leaves families in a toxic holding pattern. Children spend their formative months caught in the crossfire of unresolved living arrangements. How do you stop divided people from suing each other into the ground? In 2014, the UK government introduced a blunt legal instrument, Section 10 of the Children and Families Act. The sheer volume of cases meant the adversarial court system was no longer functional. Lawmakers recognized that out-of-court resolution could no longer be a polite suggestion. It had to become the mandatory default. Section 10 requires that before anyone can file a standard family law application, they must attend a MEAM, a mediation information and assessment meeting. This is entirely separate from couples therapy or counseling. The goal here isn't reconciliation. This diagram shows what a MEAM actually is, an impartial, forward-looking negotiation. A specially trained mediator acts as a single neutral party. They step between the combative spouses, replacing the opposing lawyers, to focus strictly on resolving practical disputes over money and children. As the two sides reach an agreement, their inputs are compiled into a single shared document. These are called the proposals. While not immediately legally binding, the parties can take this mutual agreement to a court to have it formalized. The MIAM procedure actively forces combatants to drop the pursuit of total victory. Instead of trying to defeat an adversary, they are channeled into constructing a mutual, workable future. To ensure people actually follow this rule, the system uses a strict enforcement mechanism. The courts require this specific document, the FM1 Family Mediation Assessment Form. Without the mediator's signature on this form proving attendance, judges will routinely refuse to issue proceedings or adjourn the case entirely. Alongside that procedural stick, the government offers a substantial financial carrot. This chart compares the financial realities of the two paths. On the left, a successful mediation process costs both parties a combined average of £1,641. On the right, taking that same dispute through full court litigation becomes an open-ended financial drain, easily running into the tens of thousands of pounds. To push those mediation costs even lower, the government established a £500 voucher scheme for cases involving child arrangements. And for qualifying low-income individuals, the legal aid agency covers the costs completely. By deploying unyielding procedural roadblocks alongside direct financial subsidies, lawmakers guaranteed that Section 10 cannot be easily bypassed by a frustrated public looking for a quick fight. But mandatory mediation has a critical limitation. It relies entirely on both parties having relatively equal bargaining power. If you force a victim of domestic abuse to sit across a negotiating table from their abuser, the neutral environment collapses. The imbalance of power turns a negotiation into an opportunity for further control and intimidation. To present this, the law includes strict bypass lanes to Section 10. These are specific exemptions that allow vulnerable applicants to skip the MIAM and go straight to court. Claiming domestic abuse requires concrete evidence. An applicant must provide official documentation, such as records of a police investigation, an arrest, or an existing protective injunction to trigger the exemption. The system also waives the MIAM requirement for other severe circumstances. If there is an urgent risk to life, active involvement by social services regarding child safety, or complications like international jurisdiction or bankruptcy, the case moves immediately to the courtroom. Even if the parties attend the initial meeting, the mediator holds independent authority. If they detect hidden coercion or intimidation, they can officially declare the case unsuitable for mediation and sign the forms allowing the court process to begin. Section 10 acts as a highly calibrated filter. By forcing the majority of everyday family disputes to the negotiating table, it clears the immense backlog. That preserves the protective power and the limited time of the family court, strictly for the vulnerable individuals